Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Hope you're doing good on this Thursday. This week's flown by. Man, the summer just flies. It seems like Monday, then blink, and it's almost the weekend. But hey, I'm not complaining. All right, quick music fact of the day. The Rolling Stones were formed by chance. Keith Richards and Mick Jagger met at a train station back in 1961, and they struck up a conversation about the blues records that Mick Jagger was carrying around. Well, the connection was instant. The rest is history. There you go. Thanks to everybody who's donated. I really appreciate all you guys supporting the podcast. If you haven't subscribed, hit that subscribe button here on YouTube. Give the video a like. It helps grow the podcast. I appreciate you. A little bit of news real quick before we jump into the case updates. Shiny Happy People, will there be a part 2? Well, the executive producers say 1000% yes. They are open to a sequel to this really popular and revealing documentary we just spent almost a week going through. They said that there's a lot that they have not even scratched the surface on. And also, there's a lot of stuff that wasn't put into the first part by people who spoke. And also there are other people they would like to put on camera to kind of go down some more rabbit holes. So it'll be interesting to see if there's a sequel on that. Okay, let's jump in. Lori Vallow had her hearing just a little while ago for the request for a new trial. And a big shout out to Caitlin Hart from East Idaho News for doing an amazing job tweeting. Archibald started out by saying that their client reserves all of her appellate rights other than what's in the motion for a new trial. He said he anticipates if the court were to grant the motion that the state would ask to rejoin Lori and Chad's trial. As we know, Chad's expected to go to trial April 1st of next year. Kind of ironic. It starts on April Fool's Day. Archibald said they do not object to a joinder again with Chad and says they didn't ask for the separation of the trial in the first place. He said he faults the government more than the court as far as how that indictment was filed. He argues the language in the grand jury indictment is incorrect and she should get a new trial because of that. He says there were 5 co-conspirators mentioned, only 3 named, which were Lori, Chad, and Alex. The others were not. At the end of a 7-week trial in Boise, essentially it said, talks about at the end of Lori's trial, which lasted 7, almost 8 weeks there in Boise, essentially it was said not really 5 co-conspirators, it's 2 or more based on the definition of conspiracy. He said that was a mistake by the state. Archibald said the court misled the jury and that resulted in the amended indictment. He also said the clerical error that allowed the indictment to be amended was not a clerical error. Originally, the jury instruction said and then later was modified to and or at the very end of the trial. He said the way the state drafted the indictment was prejudicial and should not have been allowed. He moved on to the interview between Nate Eaton and the juror Saul, who was a deliberating juror, by the way. He said both Nate and Saul were respectful of the process, the court staff, etc., but the juror was confused by jury instructions before deliberation began. He said if the motion is granted, they would attack the 404B evidence, which is the prior bad acts. He said most courts don't allow this character evidence because of the trap it sets. If the motion is denied, he will take it up on appeal. Then Lindsay Blake was up for the state. She addresses whether or not the jury was misdirected as to the matter of law. She said the language in the indictment doesn't matter because it actually helps the prosecution's argument. She cites cases where the indictment was amended and it did not impact the outcome of the trial and says the indictment can be amended at any time prior to the state resting their case. She said Lori was always on notice that she was charged with grand theft, which those charges were relating to the Social Security monies that she was still receiving after JJ and Tylee were murdered. Lindsay Blake also said the defense failed to meet their burden of proof. She says that even if the court would consider the juror's statements, which she said the court should not, but even if they do, the motion for a new trial would not succeed. Blake quotes the juror from the interview where he says he did not find the jury instructions to be confusing. Ultimately, that is denied. No new trial for you, Lori. Her sentencing is set for July 31st. I'll be there to bring it to you for Law and Crime Network and the podcast. And by the way, if you guys want a little bit of a smile, apparently after a short break, Lori re-entered the courtroom, ran into a wall, and nearly tripped and fell due to her shackles. So there you go. A little bit of relief for everybody because you never know with these things, but that's it. Goose cooked. All right, we're moving on to Kouri Richins. She was denied bond this week after a hearing. We know she's the mother who was accused of killing her husband with fentanyl and then went on to write a children's book about grief. Some facts did come out at this hearing. Eric Richins' phone was last used on March 3rd, 2022 at 9:58 p.m. A detective from Summit County Sheriff's Office said that a woman identified as CL, who worked for Kouri, bought fentanyl on 2 separate occasions and brought it to Kouri prior to Eric's death. A detective also said that a first responder said it was unlikely she did CPR even though she claimed she did. We've heard this several times in cases where people are saying they did CPR or pretended and they really didn't. A private investigator testified about Kouri's phone usage on March through the 4th, which was the night into the early morning hours after his alleged murder. It was unlocked at 3:07 a.m. on March 4th, and then a 911 call was made at 3:22 a.m. The phone was moved and unlocked several times in between that. The movement in the house ranged from 240 feet, and another was 130 feet before that 911 call came in, so she was moving around with her phone, it seems. Also, there were things deleted from the phone, including messages, call logs, and search history. One deleted search history was for luxury prisons for the rich. What happens to deleted message and how forensic analysts recover data from phones. People are morons. I mean, if you're going to commit a crime, don't touch your phone. I always say if I was going to commit a crime after doing true crime, I would ride a horse and leave my phone at home. Kouri called the middleman for the fentanyl that night. A financial forensics expert testified about finances. The witness looked through documents about Kouri's buying and selling of homes through her company. And in 2019, Kouri acquired 2 properties, the home they lived in, and also she had taken out a home equity line of credit taken out on this second home that she had purchased. The trust deeds went from $471,000 in 2019 to over $2 million on 5 different properties in 2020. It increased to 13 properties in 2021 for over $6 million. The witness explained that such a rapid acceleration in growth can actually be a big problem. By the end of 2021, Kouri was obligated for over $4 million on those properties. And in December of 2021, there were 94 payments that equaled $252,000. One account sued her in 2021 due to insufficient funds. The state essentially said she was just maxed out on all of her credit and she was kind of cash poor. Eric, on the other hand, had multiple life insurance policies and she was paid out $1.3 million for those policies. Eric's sister Amy gave a victim impact statement saying that Eric's life was taken in a senseless act of poisoning and she's brokenhearted. He loved his family, hunting, and his life as an entrepreneur. He coached kids' sports. He was a loving father and loved to have fun on motorized toys. She said his death has created a hole the size of the Grand Canyon in the community. And Kouri wouldn't help with the cost of the funeral, but points out that she closed on a home worth $2 million within 48 hours of his murder. She also broke into his gun safe. Kouri held a golf tournament on his 40th birthday. His family, not invited. She accused Kouri of being violent towards her, punching her, and she's cut Eric's family out of the lives of their children. The defense didn't call any witnesses, but her attorney said that this is a tragic circumstance and that she loved her husband and her kids. She said the state hasn't proven the connection between CL and Kouri, and there was no traces of fentanyl in the home. She said being bad with money doesn't make you a murderer. And she says the $1.3 million in life insurance that she cashed out didn't even come close to solving her financial problems. And her financial position was actually worse because she did not have his income to help. The state said there's substantial evidence and would be more if she had not deleted evidence. The judge said there is motive and she was denied bond. Her next appearance is June 22nd at noon. I've been on the road covering trials for 12 weeks so far this year, and Base has made my travel so much easier. It's an overpacker's dream. It can be hard to fit everything in, especially when it comes to luggage, but with Base, there's room for everything. Base was created by actress Shay Mitchell to make sleek and affordable bags, luggage, and accessories designed to help you travel effortlessly while still looking fashionable. Base has thought of everything you could ever want in a piece of luggage. 360-degree gliding wheels, a cushion handle, a built-in weight indicator that has saved me from last-minute overweight luggage fees and scrambling to balance weight between my bags. We've all been there. It also has washable bags for your dirty clothes and all the interior pockets you need to keep organized. Their luggage comes in multiple sizes and colors, and for shorter trips, the weekender bag is super functional. It even has a place to store your shoes separately. I can see why Base has over 30,000 5-star reviews, one of those from me. Right now, Base is offering my listeners 15% off your first purchase by visiting basetravel.com/whattheworld. Go to basetravel.com/whattheworld for 15% off your first purchase. That's Base, BEIS travel.com/whattheworld. So let's move on to Delphi. Richard Allen was in court today for a hearing, and the reason for this hearing kind of changed a bit over time. It was originally set up as a bond hearing. Last month, they changed it into a motion to suppress evidence, and then that was changed to a motion to have Allen move from the maximum security isolation unit at Westville Prison, where he's currently at, to the Cass County Jail in Logansport. His attorneys say that he has experienced mental and physical changes, which they attribute to him being in isolation. Apparently, Allen has made statements of admission regarding the murders. However, his attorneys are refuting that, saying that it was due to his deteriorating mental and physical condition. He's facing 2 counts of murder in the 2017 murders of Libby German and Abby Williams. His attorneys have filed a motion regarding ballistics in the case as well. They say that the ballistics and firearm evidence is inadmissible. That motion is sealed. However, the probable cause affidavit showed there was an unspent bullet that was 2 feet away from the bodies of the young women, and a ballistic examination showed extraction marks from that round had passed through the gun that they confiscated from Richard Allen's home during a search warrant. In Libby German's video, it was reported to have captured one of the girls saying the word gun after the man believed to be Allen is seen walking towards them on the bridge. In an interview with investigators in 2017, Richard Allen said he was on the trail between 1:30 to 3:30 p.m. He parked at the old CPS building and walked to the New Freedom Bridge. While at the bridge, he saw 3 females. He noted one was taller and had brown or black hair. He did not remember the description, nor did he speak with them. He walked from the Freedom Bridge to the High Bridge, and he said he didn't see anybody, although he stated he was watching a stock ticker on his phone as he walked. He stated there were vehicles parked at the High Bridge trailhead, however, did not pay attention to them. He said he did not take any photos or videos of his time on the bridge that day. In an interview on October 13th, 2022, Allen again admitted to being on the bridge February 13th of 2017. He said he walked on the bridge to watch fish in the stream below. And he said he walked to the first platform and walked back, then sat on a bench on the trail and ultimately left. He also admitted that he was wearing clothing similar to the ones seen on the video that Libby filmed just shortly before the girls were murdered. In the search warrant of his house, police seized jackets, boots, knives, and guns, including a .40 caliber pistol, which was ultimately linked to that unfired round. Allen admitted the gun was his and said he had owned it since 2001. On October 26, in another interview, he admitted again to being on the bridge, but said nobody had used his gun and he couldn't explain that unspent bullet so close to the girls' bodies. He denied being involved in the murders at that point. Authorities ultimately concluded that Allen was the only adult man in the area the day of the murders. Investigators say his own admissions make him the prime suspect. Witnesses recall seeing his car, a Ford Focus, parked in the area in that time frame that the girls were believed to have been murdered. He was not seen on the trail after 2:13 p.m. Others in the area say between 2:30 and 4:11 p.m., they did not see Allen on the trail. Investigators believe at 2:13 p.m., he was in the woods with the two victims, Abby and Libby. The document says Richard Allen stated he had not been on the property where the unspent round was found and that he did not know the property owner, and that he had no explanation as to why a round that had been cycled through his firearm would be at that location. He also stated he never allowed anyone to use or borrow the gun. Investigators believe after the victims were murdered, Richard Allen returned to his car by walking down CR 300 North. They believe he was seen by a witness walking back to his vehicle on CR 300 North with clothes that were muddy and bloody. His attorneys have criticized how the probable cause affidavit was worded. On November 22nd, his attorney, Andrew Baldwin, said, "It may be weird for defense lawyers, I suppose, to be arguing that we want things unsealed, but that's how confident we are in our client, that at least what's written in the probable cause affidavit is nothing for us to worry about. We don't know what other evidence is out there, but we're confident that whatever is out there is not going to be enough to show that our client did anything here." They say Allen is confused and bewildered about the charges, and the state, on the other hand, say their case is very solid. We're going to move on to Bryan Kohberger. His defense team is asking for more time to respond to the state's request for an alibi. The state filed a motion demanding notice of his alibi. His attorney, who is a public defender, Ann Taylor, said in a motion on Friday they have not had sufficient time to review evidence given by the prosecution, which includes thousands of pages of discovery, thousands of photographs, and hundreds of hours of recordings. His attorney said the defense needs time to make this determination and consider evidentiary rules. Idaho law states that the defendant has 10 days to offer information on whether or not they plan to provide an alibi, but a judge can extend that deadline. The judge is also expected to issue his decision on the gag order in the case, which prohibits any attorney from either side, attorneys representing witnesses, from saying anything publicly about the case. Shannon Gray, who is an attorney for Kaylee's family, asked for the gag order to be amended to allow him to speak publicly on behalf of his client, saying they are not parties or witnesses in the case and should not be subject to that gag order. Also, a media coalition argued the gag order should be removed, saying the order is vague, overbroad, unduly restrictive, and not narrowly drawn. Publicity in and of itself is not prejudicial. What they, meaning the media coalition, wants is for their reporters to be able to obtain accurate information of the kind that might help the public better understand all of this. The defense worries about not being able to find an impartial jury, but Wendy Olson, who is the attorney for the media coalition, said there are alternate ways to find an impartial jury, such as a change of venue or even sequestering the jury. In other news, the prosecution is asking for more funding to help cover expenses. They're asking for $135,000 for trial expenses. The normal amount is usually around $15,000. The increase will be paying for expert witnesses, travel fees for witnesses, exhibit displays, and also the transcript. The commissioner told the state they actually should increase the amount to $150,000. And county commissioners will adopt that yearly budget this coming September. There was also a motion filed to stay the proceedings. This was filed June 13th, so just this week. It says Bryan was indicted by a grand jury on May 16th, 2023. He filed a motion to make available the record of all proceedings of the grand jury and a motion requesting the release of grand jury materials under qualified protective order on May 19th. The parties are unable to reach an agreement about the release of the grand jury material. On June 6th, the state filed their state supplemental response to defendants' motions regarding grand jury record and transcript. There's a hearing scheduled for June 26th about this issue. It says Mr. Kohberger stood silent at his initial arraignment to preserve his right to contest the indictment. He also asserted his right to a speedy trial. A jury trial is expected to begin October 2nd of this year, and time is of the essence. By the time the court hears arguments on the preparation of the grand jury proceedings, almost 6 weeks will have passed from the time of the indictment. Mr. Kohberger has the right and intends to contest the indictment. They list Idaho Code 2-213 allows the defense to seek stay of proceedings within 7 days after the moving party discovers or by the exercise of diligence could have discovered the grounds therefore, and in any event before the trial jury is sworn to try the case, a party may move to stay the proceedings and in criminal case to quash the indictment or for other appropriate relief on the grounds of substantial failure to comply with this chapter in selecting the grand or trial jury. The state responded and says they acknowledge the discovery in this case is huge and ongoing, and the jury trial is set for 4 to 6 weeks, which is less than 4 months. They do not object to the extended time, but they do ask for reasonable time for the state to respond to any notice of alibi that is filed. So we'll keep an eye on all that. Last little bit of an update for today. A judge denied the Laundire's request to toss the lawsuit between Gabby Petito's parents and Bryan's parents. The Petitos have filed to get any messages, text messages, inboxes, WhatsApp, any way you can message somebody between Bryan and his parents between August 27th, 2021 through the date Bryan died. The trial is set to begin in May of next year. So that's kind of it for today. A little bit of a shorter one. Just wanted to update on some things. I appreciate all y'all. I will see you guys very soon.